Um, Ladies and gentlemen of the jury, as I stated earlier, you have received all of the evidence that you were to receive in this case. I am now ready to read the instructions to this jury and to charge you with the law in this case. Please listen carefully. We've also given you all a copy. Feel free to follow along with the reading, or just whatever you prefer. In cause number 2019 CVA 22061, the case was Marlene Mar versus Emma Carrizales. One second. I might have sent you the wrong one. All right? Yeah. All right, folks, can you send that back this way? It's the wrong one. One second. Stay right where you are. I attached the wrong document to my coordinator when I sent it to her. So you all had the right one, but the one I printed for them was the incorrect one. Think somebody did? Was it you? Or somebody not? All right, almost there. So now, in this case, of Marlene Mar versus Emma Carrizales, this is the charge of the court. Ladies and gentlemen of the jury, after the closing arguments, you will go to the jury room to decide the case, answer the questions that are attached, and reach a verdict. You may discuss the case with the jurors only when you are all together in the jury room. Remember my previous instructions. Do not discuss the case with anyone, either in person or by any other means. Do not do any independent investigation about the case or conduct any research. Do not look up any words in dictionaries or on the internet. Do not post information about the case on the internet. Do not share any special knowledge or experiences with the other jurors. Do not use your phones or any other electronic devices during deliberations for any reasons. Here are the instructions for answering the questions. Do not let bias, prejudice, or sympathy play any part in your decision. Base your answers only on the evidence admitted in court and on the law that is in those instructions and questions. Do not consider or discuss any evidence that was not admitted in the courtroom. You are not to make up your own minds about the facts. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. But on matters of law, you must follow all of my instructions. If my instructions use a word in a way that is different from its ordinary meaning, use the meaning I give you, which will be a proper legal definition. All the questions and answers are important. No one should say that any question or answer is not important. Answer yes or no to all the questions unless you are told otherwise. A yes answer must be based on a preponderance of the evidence. Whenever a question requires an answer other than yes or no, your answer must be based on a preponderance of the evidence. The term preponderance of the evidence means the greater weight of credible evidence presented in this case. If you do not find that preponderance of the evidence supports a yes answer, then answer no. A preponderance of the evidence is not measured by the number of witnesses or by the number of documents admitted in evidence. For a fact to be proved by a preponderance of the evidence, you must find that the fact is more likely true than not. Do not decide who you think should win before you answer the question, and then just answer the questions to match your decisions. Answer each question carefully without considering who will win. Do not discuss or consider the effect your answers will have. Do not answer questions by drawing straws or by any method of chance. Some questions might ask you for a dollar amount. Do not agree in advance to decide on the dollar amount by adding each other's jurors' amounts and then figuring the average. Do not trade your answers. For example, do not say, I will answer this question your way if you answer another question my way. The answer to the questions must be based on the decisions of at least 10 of the 12 jurors. The same 10 jurors must agree on every answer. Do not agree to be bound by a vote of anything less than 10 jurors, even if it would be a majority. As I have said before, if you do not follow these instructions, you will be guilty of juror misconduct, and I might have to order a new trial and start this process over again. This would waste your time and the party's money and would require the taxpayers of this county to pay for another trial. If a juror breaks any of these rules, tell that person to stop and report it to me immediately. Any notes you have taken are for your own personal use. You may take your notes back into the jury room and consult them during deliberations, but do not show or read your notes to your fellow jurors during deliberations. Your notes are not evidence. Each of you should rely on your independent recollection of the evidence and not be influenced by the fact that another juror has or has not taken notes. Occasionally, during jury deliberations, a dispute arises as to the testimony presented. If this should occur in this case, you shall inform the court and request that the court read the portion of the disputed testimony to you from the official transcript. You shall not rely on your notes to resolve the dispute because those notes, if any, are not official transcripts. The dispute must be settled by the official transcript, for it is the official transcript rather than any juror's notes upon which you must base your determination of the facts and ultimately your verdict in this case. You must leave your notes with the bailiff when you are not deliberating. The bailiff will give your notes to me promptly after collecting them from you. I will make sure your notes are kept in a safe, secure location and not disclosed to anyone. After you complete your deliberations, the bailiff will collect your notes. When you are released from the jury duty, the bailiff will promptly destroy your notes. When words are used in discharge in a sense that varies from the meaning commonly understood, you are given a proper legal definition which you are bound to accept in place of my other meaning. Answer yes or no to all the questions unless otherwise instructed. A yes answer must be based on a preponderance of the evidence unless otherwise instructed. If you do not find that a preponderance of the evidence supports a yes answer, then answer no. Definitions. Negligence means failure to use ordinary care, that is, failing to do that which a person of ordinary prudence would have done under the same or similar circumstances, or doing that which a person of ordinary prudence would not have done under the same or similar circumstances. Ordinary care means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. Preponderance of the evidence means the greater weight and degree of credible testimony or evidence introduced before you and admitted in this case. Proximate cause means that cause which, in a natural and continuous sequence, produces an event, and without which cause such event would not have occurred. In order to be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen that the event or similar event might reasonably result therefrom. There may be more than one proximate cause of an event. Circumstantial evidence is a fact that may be established by direct evidence or by circumstantial evidence or both. A fact is established by direct evidence when proved by a witness who saw that act done or heard the word spoken, or by documentary evidence. A fact is established by circumstantial evidence when it may be fairly and reasonably inferred from other facts proved. Injury means a person is injured if they receive damage or harm to the physical structure of the body. Such damage or harm includes such disease and infectious as naturally result therefrom, and the acceleration or aggravation of any previously existing disease or condition, by reason of such damage or harm to the physical structure of the body. Question 1. Did the negligence of Emma Carrizales cause the injury in question? Answer yes or no in the blank. If you answer yes to question 1, then answer the following question. Otherwise, do not answer the following question. Question 2. What sum of money, if paid now in cash, would fairly and reasonably compensate plaintiff Marlene Mab for her injuries, if any, that resulted from the occurrence of November 12, 2017? Consider the elements of damage listed below and none other. Consider each element separately. Do not award any sum of money on any element if you have otherwise under some other element awarded a sum of money for the same loss. That is, do not compensate twice for the same loss, if any. Do not include interest on any amount of damages you find. Answer separately in dollars and cents for damages, if any. A. Physical pain sustained in the past. B. Physical pain in the future. C. Mental anguish sustained in the past. D. Mental anguish in the future. E. Physical impairment sustained in the past. F. Physical impairment sustained in the future. G. Reasonable expenses of necessary medical care incurred in the past. And H. Reasonable expenses of necessary medical care that in reasonable probability Marlene Mab will incur in the future. Instructions for the presiding juror. When you go into the juror room to answer the questions, the first thing you will need to do is choose a presiding juror. The presiding juror has these duties. Have the complete charge read aloud if it will be helpful to your deliberations. Preside over your deliberations, meaning manage the discussions and see that you follow these instructions. Give written questions or comments to the bailiff who will give them to the judge. Write down the answers you agree on. Get the signatures for the verdict certificate and notify the bailiff that you have reached a verdict. Do you understand the duties of the presiding jurors? If you do not, please let me know. Instructions for the signing of the verdict certificate. You may answer the questions on a vote of 10 jurors. The same 10 jurors must agree on every answer in the charge. This means you may not have one group of 10 jurors agree on one answer and a different group of 10 jurors agree on another answer. If 10 jurors agree on every answer, those 10 jurors sign the verdict. If 11 jurors agree on every answer, those 11 jurors sign the verdict. If all 12 of you agree on every answer, you are unanimous, and only the presiding juror signs the verdict certificate. All jurors should deliberate on every question. You may end up with all 12 of you agreeing on some answers, while only 10 or 11 of you agree on other answers. But when you sign the verdict, only those 10 who agree on every answer will sign the verdict certificate. Once again, do you understand these instructions? The verdict certificate is attached. We will commence with the plaintiffs giving you their closing arguments. Mr. Jones.
Thank you, Your Honor. Good morning, ladies and gentlemen of the jury. Again, on behalf of my client, Marlene Marr, I want to thank you for coming down here and being on this jury, because as we told you when we were picking you, it's been a while since we've been able to stand here in the courtroom and present cases and try cases. Because of COVID and a lot of things out of our control, we weren't able to do that. And it's like anything, like I told you, if you don't get to do it, you really start to miss it. But Ms. Marr has waited almost 5 years to come before you as a jury.
Objection, I'll start approaching for that. Approach. No, but he didn't blame anybody. He just said he did. It's not about it. I can't hear you. Yeah, what I granted was that he wasn't going to blame the defendant.
Again, ladies and gentlemen, it's been 5 years since this wreck. And we finally got a jury to hear the evidence and do what is right in this case. And again, I appreciate it. It's been a pleasure representing Ms. Marr. I've tried a lot of cases, and cases come down to credibility. And Ms. Marr is the picture of credibility. She's a woman here from Laredo. She went to school here in Laredo. She went to college here in Laredo. She married her high school sweetheart, who's a Border Patrol agent here in Laredo. She has 2 beautiful children, and she's expecting another one. She is the salt of the earth. She is the type of person that I would represent any day of the week. There is not any flaw in her credibility, and that's what this case comes down to. Do you believe her, or do you believe somebody they hired from Corpus Christi to come up here and tell you he looked at the x-rays, he's never seen the patient, he's never read her deposition, he doesn't know who she is, he probably couldn't identify her in the courtroom, and tell you folks from Laredo that none of your healthcare providers are any good here. They're wrong. This lady's been treated for almost 1.5 years and lived with pain for the last 5 years, and she's
Give me a second, Mr. Jones.
That was mischaracterizing the testimony of.
I'm sorry. Overruled.
Let
The
me
jury
tell you,
will be the sole, you will do your best to recollect the evidence, and you'll be the ultimate decider of what the evidence was and the facts in this case. Thank you.
and as far as I told you when we were picking you as a jury, there was going to be an issue as to property. And all of you took an oath that you can listen to the evidence here in the court. That you wouldn't have any preconceived idea because you don't see any property damage, or the property damage is very little. There might be other factors to consider. And you heard those other factors. When this collision happened, when this lady's Jeep ran into the back passenger side of my client's vehicle, which was a lot smaller, and got hit by a big Jeep, she was turned in an awkward angle, doing something with her son. and she looked up, and that's when the collision happened, and she was thrown around the car, her neck was thrown back, and she hit the back pillar of the car. That's not an ordinary accident. That accident is specific to this case. So when you look at pictures, that's not the whole story. What happened to her body? Did you see any evidence in this case that Miss Marr had any neck or back pain prior to this wreck? Not one shred of evidence, and believe me, if there had been, you'd see it in this courtroom. What happened? She wanted to try to get herself, going on. She didn't want to go to the doctor. She didn't want to go to the emergency room. She's like all of us. And hopefully I'm not hurt that bad. But what did she do? It didn't work. So she went to see a doctor because her neck and her back were bothering her, and she knew something was wrong. Now, Tony, go ahead if you'll. We talked about preponderance of the evidence. It's in there. I told you about it when we were picking the jury. It's a slight tipping of the scale. It was like I told you the Cowboys, that was Monday. It was a lot longer than that, but anyway, that was Monday. Well, they won more than by 1 point. They won by a touchdown, which is great if you're a Cowboys fan. But they didn't need to. They just needed to slightly tip the scale. That's our burden. And we met that burden. And we won by probably a couple more touchdowns. But, when you look at the evidence, it's overwhelming. Go ahead, Tony. Again, it's a slight tipping of the scales. Go ahead, next one. Negligence. Are we really here to decide negligence? Ms. Gonzalez, the defendant, is a nice lady. She didn't intentionally hurt my client. I like her. She's a nice person. But, nice people are negligent. That's life. You can be a great driver all your life, but it only takes one stop sign to change that. And that's what happened here. She admitted to you. She was honest. She admitted to you, yes, I came at a stop sign. I went through it. I shouldn't have. The Exhibit 14, the police officer's report, which is in evidence. Look at 14. Here it is, in black and white. Oh, I'm sorry. Well,
Right here.
in black and white, here it is. Sooner or later, it'll be here. Here it is, right here. Failed to yield right away, resulting in accident. Do we really need to be here for this? This case is all about them believing that Miss Marr has faked all this. She shouldn't have gotten this treatment. There's no reason to waste anybody's time. This is a fender bender, and she had little soft tissue injuries, and she should be happy with that. Well, that's not why we're here. We're here because Miss Marr had a serious injury. Now, let me tell you, when you get here's all the plaintiffs' exhibits 1 through 14. But when you get into the jury room, the medical records and the expenses, we have to prove them up through legal means. So the first pages of these medical expenses is all legal stuff. The medical records, which are in evidence and you need to look at and consider, and I didn't read all these into, but I'm going to show you a few things. That's what you need to look at. That's where the story about Miss Marr's injury and the real treatment she got from real doctors that really saw her, not one from Corpus Christi and one affidavit from a doctor that doesn't think the rates are too high, which they'll come up here and tell you these expenses are too high. There's not one doctor that Miss Marr saw that charges $3,500 an hour to sit in a room from 10:30 to almost 3:30 to testify, then testifies for maybe an hour, and then driving home makes another $3,500. And they want to tell you her medical expenses are not reasonable. Now, when you look at the medical records, look at what happened. What do you do as a reasonable, normal person? You get hurt, you hope it goes away, You go see a doctor. That's what she did. She went to see Dr. Setliff. She didn't see him in May. She saw him. History of injury. Here we go. History of injury.
Give me a second.
Objection. He's not using the actual records that are in evidence, he's using other records to show the jury.
As long as it's the same thing, it's okay. Is it the same one?
Came right out of the exhibit. Your Honor, I highlighted it for closing
Okay.
argument purposes.
That's fine.
Let's talk about this. It says Ms. Marr presented our office 3 days after the wreck, 11/15/17, concerning injuries she sustained as a result of an auto accident on November 12th, 2017. That wasn't a week later. That wasn't a month later. That wasn't a year later. That was within 3 days of this wreck. That's what a normal person does. And then we go on. We go on and you read that definition about injury. It's injury to your body and the structure of your body. So what does she do? She has these treatments. The doctor thinks she needs to have an MRI. What does she do? She goes and gets an MRI from LMJ Imaging here in Laredo that has board certified radiologists reading x-rays and MRIs, which she had. She had it on her lumbar spine. What does it say? L4, L5, disc herniation. L5, S1, disc herniation from her treating physicians. That is a injury to your body when you have a herniated disc. And remember this, at the time of the wreck, Miss Marr was 26 years old. You heard Dr. Ramos come up here and say, well, there's dehydration of this and there's dehydration of that, and it's usually aging. She's 26 years old. 26-year-old people as active as her don't have damage to their disc unless it's caused by trauma in this type of situation. Okay, so what do? Not only was her neck injured, but her back, but her neck. She was having pain in her neck, radiating in her shoulders and arms, also her lower back into her legs. They took an MRI of her neck. What does it say? C3, 4, C4, 5, disc herniation, which impinge upon the anterior cecal sac, which even Dr. Ramos said, yes, if a herniated disc impinges on your nerves, your cecal sac, it's going to cause pain that radiates into your shoulders, into your arms. Exactly what is happening to Miss Marr. And again, the neck MRI clearly says disc herniation with impingement 2 millimeters, 2.5 millimeters. Then we get in, after she saw the chiropractor said, I did what I can do for you. Dr. Setliff said, I've done everything I can do. You need a pain management specialist. So he referred her to the pain management pain clinic here in Laredo. And what did they do? They examined her, and these are some of her records. You look at her records. Patient has suffered chronic disabling pain, which caused psychological, social, physical impairment. And you go on, I'm not going to read it. Needs interventional pain management. That's epidural steroid injections. She has, it has decreased her social, psychological, emotional, and physical impairment created by painful symptoms. You heard Ms. Marr tell you about how it hurts to not be able to take care of her kids, not to go on activities with her kids. How this has affected every aspect of her daily life, her routine. She used to be active and she used to jog. We're not in here saying she's totally disabled. She's not. But she's living with chronic pain. And as she told you, it's waves of pain. Certainly she has good days and the pain is not that bad. But then a wave of pain comes in that evening or the next day. It can't be controlled. She never knows. She goes to bed every night has trouble sleeping and doesn't know, and she knows she's going to be tense the next morning when she wakes up. She's going to have numbing pain. That's always there. But she doesn't know if these waves of pain are going to come, whether she's going to have a 4-day or a 6-day or a 9-day as far as pain level. And she has to modify her lifestyle. She told you all about that. She did a pain assessment at the pain clinic, and exactly what she told you in her testimony. Here are the areas that she said were causing her chronic pain and that she was getting treated for. Consistently, that's credibility. Consistently, and consistent testimony is credibility. And I'm not going to read all these medical records. You folks are probably a lot smarter than I am. You can read them, but I want you to show you these, because we didn't read them into evidence. We got them into evidence, but these are her medical records. These are from her treating physicians. And then we look another acute low back pain with bilateral leg pain, acute neck pain with bilateral shoulder pain. Again, consistently. Pain level this particular day was 4 out of 10. Shooting pain, stabbing pain she had complained of consistently since this wreck. Then it was not only the result of her injuries, but you heard her testify how terrified she was when the doctor told her, you need to consider having a needle stuck into your back and your neck so I can try to alleviate some of this pain. And you heard her testimony. This was not an easy decision. It's a complex medical procedure, and it has a lot of risk. And she's a young mother. That's nothing you do if you're not in severe pain. You don't have a doctor stick a 3.5-inch needle into your neck, into your spinal cord, and into your back, and she had 2 sets of those and had to go in there, and it's a surgical procedure. You don't do that unless you have very, very severe pain, and you'll do anything. And this is another thing. You know, we talked about pain levels. This is in her records too. This was one of the days where she was having a wave of pain. What is your pain level at its worst? 9 today. When you look at that, you know, the answer to number 1 is yes. You know, the defendant was negligent. Ordinary people don't roll through and hit people and run stop signs. You don't do that. If we did, none of us would be driving. This case is about damages. Go back to that. What is Ms. Marr legally entitled? And that's, you know, that is a hard question. I mean, what is pain worth? You know, we all pay something to get alleviated from pain, whether it be a bottle of Tylenol, or whether it be an epidural steroid injection, or when I go to the dentist, I don't just like Novocaine. I like to have them put me out. I hate the dentist, but I pay a lot to get out of pain. And we all do. We all have our own threshold. But we all consistently know that. Go ahead. And again, negligence. I don't think there's any. That's not why we're here. That's clearly yes. And you'll have this in the jury room, and you'll have the definitions. And again, these are the definitions I asked you about when we were picking a jury. Again, I submit to you the answer, especially issue number 1, is clearly yes. There's no other answer for that. Now let's talk about damages. Let's get to the damages. That's tough. These are her medical providers. Again, if you look in the exhibits, all those medical have been proven up through the medical facility. She has $30,000 in past medical expenses. That figure is easily calculated. You just look at her bills, and that's what she owes. She told you she owes it. She's legally responsible for it. She's going to pay it either through this lawsuit or she's going to work out a payment plan. But these other damages are tough when you start talking about pain and suffering. And I think I would suggest to you, the R times R formula is a good way to try to think about damages. You have a reasonable time, reasonable rate, reasonable verdict, a reasonable amount. Next one, Tony. You look at this wreck happened November 12, 2000, until today's date. That's 1,781 days. And you take that, and she did have another accident. It was in May of 2002. She didn't try to hide that from you, and that shook her up for about 3 months and made her symptoms a little worse. And we're taking that out. That was about 90 days. So if you take those 90 days out, you're left with 1,691 days. Well, you take that and say she just suffers some kind of pain 8 hours a day. Out of 24, she has some type of pain. That's 13,528 hours. You take that and say you give her $10 an hour, whether the pain is a 4 or a 9, you average it. Is $10 an hour too much to pay to be compensated for living in pain? If you think it's more than that, you can use that. If you think it's less than that, certainly. That's just a suggestion. When you look at how long it's been, this is in the past. Remember, Ms. Marr, and the court has told you to take judicial notice, under our U.S. Census tables, and the government says she's going to live another 54, 55 years. That doesn't mean she's going to be in pain all those 54, 55 years, but you've heard her testify. She's going to have to get an opinion from an orthopedic surgeon at some point, and she's still living in daily pain. Go ahead, Tony. And so you look at the damages. Again, medical expenses is easy. She's going to have some future medical care. That's probably $10,000. You take the pain and suffering and at $10 an hour in the past for all those hours, all those days, it's probably about $135,000. Your future, $50,000. She's going to live maybe 50 more years, maybe $10,000 a year. You take the mental anguish in the past. That's half of what her $135,000 for the past. For mental anguish in the future, $25,000. Again, these are suggestions to you. You can make them more, you can make them less. Impairment, she told you how bad she feels, how she can't do not anything, but a lot of the things she used to do and used to take for granted, everything from homework, working around the home, cooking, taking her kids to the park. And then the future impairment, she's going to have that for a significant part of the rest of her life. So those are suggestions, but those are hard. Those are numbers that are hard. That's why we have people like you, so we can have reasonable discussions and reasonable awards for people that have been injured. And the injury, under our law, the injury is legally, she has a right to be compensated. Not only compensated for the injury, but fully and fairly compensated. And again, that's what you folks are. You are the voice of the community. You tell us what you think these things are worth, what the value is for someone who's gone through what Ms. Marr said. And with that, I'll address you just a little bit later. Thank you.
Okay, please report. Counsel. Ladies and gentlemen of the jury. Good morning. So, we're here. We're at it. We've discussed things over the last few days. We've heard testimony. We've admitted evidence. It's very important that when you go back in the jury room, that the judge told you that you're able to communicate with the bailiff through notes. And you're not automatically given that evidence, so you need to send a note to request the evidence. So we strongly suggest that you do so that you can look at everything yourself. You can look through the medical records. You can look through all the bills that they're proposing. You can look through all of that, and you can make the decision yourself. That's what we're here for. We stand up every single time that y'all come in this room because every single one of you are the judges of the facts of this case. You decide what happens here today. And we thank you for your service. We thank you for the time that you've been here. You know, I know it's been a lot of hurry up and wait, but, you know, juries are what make America great. We're the only country that has this system. And so we thank you for your service deeply on behalf of myself, Ms. Campos de la Garza, and Ms. Carrizales. So I'm going to point out some things for you today. Peyton's going to be helping me out, so I'll be letting her know next. I don't want to order her around or anything, but I don't have no clue. So if we could start on the first one. November 12th, 2017. Now you heard testimony, and you'll see also in the medical records that she did not seek treatment for 3 days. But yet she told you, you know, automatically after the accident, her legs were tingling, right? She's never felt that pain before. And the next day, she woke up, she was sore, constant pain. Stopped seek medical treatment that day, the day after that, and then she went to the chiropractor. So she did seek treatment after 3 days. But where did she go right after? She continued to the mall. Actions speak louder than words. What are her actions telling you? You heard her say bunch of things. But what are the actions telling you? What are the medical bills telling you? I'm sorry, what are the medical records telling you? On November 2017, she only treated once for the entire month. December 2017, once the entire month. January 2018, she's released from the chiropractic treatment. She undergoes the lumbar ESI, and she has a lumbar MRI. You heard from Dr. Ramos. Dr. Ramos told you in all of his experience, and the CP here is in evidence, you know, through the 70s, through his own practice. I understand that plaintiff's counsel wants you to think, you know, because he was paid for his time here, that it automatically discredits him. You have his CV in front of you. You heard his experience. And he was here after he interpreted the films, after he looked at her records, and for all that experience, told you that there was nothing on that lumbar MRI. Nothing. Now, after January 2018, she goes February 2018 for one treatment. She was treated once. Now, she came up here and she told you about the constant pain, the waves of pain that come over her all the time. Actions speak louder than words. Why aren't you getting treatment? Why aren't you going and seeking help? She's talking about the pain. She's not doing anything about it. March 2018. Treated once for the entire month. And she gets another ESI. This one was zero. April 2018. Treated once for the entire month. On April 20th, 2018, she was ordered to have an additional ESI on April 30th. Did she show up? No. Actions speak louder than words. Also, we're going to go through some of the individual visits in a minute, but she didn't note any migraines. She didn't note any headaches. And after this, she didn't seek treatment in May, in June, in July, August, September, October, November, December, the rest of the year, no treatment at all. She told you that she started a new job, and so if the job didn't allow her, she didn't want to be that person. For 10 months, but she's in constant pain. She's in these waves of pain. Actions speak louder than words. In January 2019, 14 months after the accident, she decides that she's going to go ahead and have that ESI, as she was ordered to in April of 2018. The doctor noted, and we'll go through this visit, she was not complying with her medication. She decided to stop taking her medication all on her own, that she did not have migraines, did not report depression, did not report sleep disturbances, but she underwent the lumbar and cervical ESI that she was terrified of, as she testified. The next month, only treated once. This was her last one. And her pain level at the end of her treatment, 1 out of 10. She told you that's minimal pain. She did not get treated at any other point for this case after February 2019. These were her final instructions. The doctor asked her to return to the pain clinic on March 1st, 2019. She has testified, and you have heard this evidence, that she has not sought any doctor, any treatment since February 2019. She disregarded doctor's instructions multiple times. She has not followed up, and nowhere, you can look at the evidence, look at the medical records, nowhere did they ever recommend her to an orthopedic surgeon. You will not find it in the records. I promise you. She was instructed to come back in March. She was never recommended surgery. That was the excuse that she's given you. She's just not ready for surgery. Who said she needs surgery? Who said that? No doctor that treated her said she needed surgery. March 2019 to December 2019, all of 2020, all of 2021, no treatment. Nothing. This year, no treatment for this accident. But she did get treatment for another accident she was involved in May 2022. Yet, you just saw her attorney tell you that for all of the hours that she hasn't sought any of this treatment, he wants you to give her $10 an hour for 8 hours a day of pain. He wants you to award Miss Mar more than $370,000 for this accident, on top of her past medical bills. But we don't even get to that point, because what we and what you need to decide in this case is the most critical part. Did this accident cause her injuries? We talked about the negligence, talked about all of that. My client was honest with you. My client took responsibility. But this accident did not cause these injuries. The pain that she said that she feels today, she had multiple children, she had COVID. All of these things may contribute to her, I don't know. But is it more likely than not that life has been rough, or that it's this accident? This is the day. And she wants you to all believe that more likely than not, this is what has caused her injuries. 4 years and 10 months later. Now, my colleague, Ms. Garza, came up to you at the beginning of this trial, and she asked you not to leave the common sense of the door. Now, that's the extent of the damage. It's not over here where she was sitting. It's over here. You can see this. You can inspect it. You can look at it. Now, this morning you heard testimony from Ms. Muck. I didn't even ask her any questions because I didn't think there was really a point. But she told you that my client reversed back after this accident. She told you that she agreed from everything else of the police report except for the diagram that corresponds with this photo, because she wants to pick and choose what's true, what's not true. But she doesn't get to do that. You are the judges of the facts. Now, this was the damage to my client's vehicle. That was it. You heard my client testify that her bumper was made of plastic. And that was the extent. Now, I understand that plaintiff's counsel has told you that this isn't about property damage. This isn't about these photos. This is about her injury. That's right. But we were not the cause of this injury. Read through the evidence. Look at the photos. Request them. Now, plaintiff's counsel told you that we disagree with the bills, and we do. We disagree in particular with the ESIs. And we disagree with that because, as Dr. Ramos told you, she didn't have anything wrong with her lumbar spine. And anything that she had wrong with her cervical spine was likely degenerative. And he wants you to believe that she had no issues and no problems with her back then. She got on that stand and she testified that she had prior adjustments, that she was a Crown chiropractor before. Does that mean that she didn't have any injuries before? She didn't have any pain before? Use your common sense. Please. Now, this is the counter affidavit that we provided, that is in evidence. And we believe, per this expert, that there are certain CPT codes, certain things that on the bill for the pain management in particular are too high. Her pain management bill alone is $24,000. That's for 2 sets of injections and her visits. Now, this counter, add it all up, it's about $10,000. But we don't even believe that we'll get there. Now, question 1. Did the negligence of my client, Emma Carizales, cause the injury in question? Use your common sense. Look at the photos. Listen to everything that she had said. Remember her testimony. There's no way that this accident is what caused your injuries. So we would say no. And then you're done. In the event that you do answer yes, you go to question 2. What sum of money would you award? Physical pain sustained in the past. And we have a bunch of these. But if you want to give her something, our suggestion would be for the past, $500. For the future, that was done when she had her May 2022 accident. She told you, she testified that her injuries were aggravated by the subsequent accident. She told you in the definition of injury that we have here. A person is injured if they receive damage or harm to the physical structure of the body. Such damage or harm includes such diseases and infections as naturally result therefrom, and or the aggravation of any previously existing disease or condition. For injuries, if you believe that she was even injured, stopped in May 2022. 0. And so anguish. She did testify as to her mental anguish. If you're so inclined to give her anything for that, we would say 500. For the future, done, 0. Same thing for the physical impairment. 0. Reasonable expenses of necessary medical care incurred in the past. Now, she did get help. She did get treatment after the accident. She went to get chiropractic. That total is around $1,500. If you are so inclined to award her something, we would say the $1,500 from chiro. Future, step. That's cut off. It's up to you. All of this is up to you. We talked about jury selection, frivolous lawsuits. We talked about tort reform. We talked about different things. Some of you may have said that you believe that there needs to be a cap. You, today, are the cap. You make that difference. This decision matters. It matters to my client, who has also waited a significant amount of time for her day in court. Now, COVID changed the world. We're in a different world now. And that's what prolonged all of this. But now that we're here, and now that the decision is before you, I ask that you please do not put this lightly. Please consider everything. Thank you for your time.
Thank you, Mr. Jones. Mr.
Judge,
Jones,
how-
you have about 8 minutes.
Again, I'm going to use my last eight minutes or so, and you know, it's just amazing when you came in here to be jurors, you took the oath to consider the evidence. You didn't take an oath to take the easy way out. They would love you to answer number one, no, because they want you to take the easy way out, just like they've been doing with Miss Marr. Take the easy way out. Just ignore the facts. And let's take the easy way out, and then we don't have to worry about damages. That's not your oath. Your oath was to listen to the evidence. The evidence is it definitely caused Miss Marr injury. If you don't believe the credibility of this woman, I don't know who you can believe. She, again, is the salt of the earth. She is Laredo. She's not in here lying to you. She's not in here telling you about how she tossed at night thinking about having a needle stuck in her back because she was in so much pain and wanted to try to enjoy her life again, or at least get some relief from pain. You don't do that unless you're in severe pain. And believe me, the defense lawyers are very good lawyers. If they would have had one shred of paper, one medical bill, one medical record that Miss Marr had any neck or back pain prior to this wreck, it'd be right there in evidence. Where is it? Actions speak louder than words. They don't have it. So what they're doing is they're telling you to take the easy way out. They're setting up these smoke screens about, oh, you know, look at the property damage. You all told me. You took an oath. Property damage is one factor, but you would consider all factors. She was hit by a Jeep Rubicon directly where she was sitting, turned, taking care of her kid. That is what makes this case different. That's what distinguishes any property damage. We're not here talking about property damage. We're here talking about a woman that has been severely injured. She's not disabled and will never want you to do or consider that, and she's never said that. But she is injured, and it is a serious injury, and it was caused by this wreck. And you, under your oath, have an obligation, a duty to fully and fairly evaluate these damages and fully compensate her for what she's been through. And she was honest with you. Yes, she wasn't another accident. And she told you her pain level went up for about 90 days, 3 months. But then she got back to right where she was before with the same pain level, the same thing she was going through. Don't take the easy way out. Do your duty. Fully and fairly compensate Miss Marr for what she's been through and what she's going to have to go through in the future. Thank you. And again, I appreciate all your time.
Thank you, Mr. Jones. Ladies and gentlemen of the jury, we are done with the presentation of the arguments. I'm about to excuse you one last time to go into the jury room for deliberations, and now giving you the case so that you can start that with each other. Please do so under the instructions that I have given you. Thank you so much. And importantly, the food just got here about 2 or 3 minutes ago.